The problem is, what effect do these have as law, and what do you make of them? One certainly should not underestimate the ingenuity of courts. The German Constitutional Court has used Article 2.2, guaranteeing human dignity, and Article 1.1, guaranteeing the right to life, to generate a fair amount of positive obligations of the state with regard to welfare rights. And indeed, even Greece has almost been affected by the German Constitutional Court when attempts were made to keep Germany from contributing some share to the bailout of the Greek economy in the last few months. So I do not know what will or will not develop using these hortatory rights either in Greece or in Germany. All I do want to say is that insofar as it puts on the courts the obligation to develop a workable regime, that raises serious issues. And it also raises the issue which is hidden from us, at least most of the time, namely that the organization of our court systems reflect very fundamental differences of approach towards the issues of government and the relationship among the various branches of government. Let me take the last point first. In the United States, as Bill Clinton realized, no money can come out of the government unless it's been appropriated. And it is also impossible for the government to borrow money unless it's been authorized. And the way Congress authorizes the government to borrow is by setting a debt limit. And when the debt limit is reached, the government has to shut down because the U.S. government operates on a cash basis. And when I was younger, periodically in the 50s and 60s, let's say when I first started practicing law, it was a political game where the Congress would often refuse to raise the debt limit and wait until the last hour or so before the government would have stopped operating, before it caved. And there was one funny example, which I actually told John Harris about, involving C. Douglas Dillon, who was the Secretary of the Treasury in the early 1960s when John Kennedy made him Secretary of the Treasury. He had previously been Deputy Secretary of State. You know who the Dillons are, not only very rich people, but they own Chateau Aubryon and La Mission Aubryon now, and several other vineyards, and et cetera, et cetera. But at any rate, they had reached the debt limit, and the country was about to default. And a friend of mine, who was his aide, said, "What are we going to do about it?" He says, "How much are we going to go under if, at least, let's see if we can get by today. How much do we need?" He said, "Well, 400 million. At that time, the law, and it still provides, is if someone borrows money that is not authorized, the Secretary of the Treasury is personally responsible for it. Nowadays, the sums are so large that only Bill Gates or Warren Buffett could even be engaged in this game. But in those days, 400 million, which is still a lot of money, even now it's a lot of money, but in those days I reckon it would be about 4 or 5 billion. He says, "Well, give me some time to think about it." So he takes out his checkbook, he looks at the figures, he says, "No, I can cover that. Just barely, but I can cover that." So you go out and borrow the money so we can meet our obligations. As it turned out, they didn't need to, because at about 4:45, Congress threw in the sponge and said, "All right, you can have the money." But that's an important issue, because, parliamentary government in England is really based on taxation issues to a large extent, as Parliament insisted on getting more and more powers. And of course, no taxation without representation is one of the slogans of the Americans during the War of of Independence, as we call it, maybe a war of rebellion from the British side. And if you ever get to Washington, D.C., actually, you look at some of the license plates which say no taxation without representation, because the District of Columbia has no representation in the House of Representatives. So they have a person who is paid the same salary as a representative, but she, because it's a woman right now, but she gets no vote. So, but she can sit and hear the debates, and she has the privileges and the pensions and what have you that go with being a representative. So that's a serious issue which has to be confronted. Now, let's look at it also from the perspective of the courts. The courts function best when they serve as a means for implementing the law, for ensuring fairness, procedural regularity, and to varying extents, serve as a buffer between the state and the citizen. That's particularly true in the United States, and as Professor Nielsen pointed out, in the United States, where freedom is considered to be a key value, that's an important function. And the function can also be seen in what we consider the localism of U.S. law. For example, the insistence on jury trials, and not only in criminal cases, but also in civil cases. The extreme, I suppose, in localism is probably, I'm sure it's not the only state, but North Carolina is one of the few places in the world where if you are being prosecuted for a felony, your options are either to plead guilty or to be tried by a jury. There is no possibility of being tried by a judge alone in North Carolina and the United States of America. No possibility whatsoever. And the jury will consist of 12 people, and it must come with a unanimous verdict. All 12 have to agree. Otherwise, you walk out. Now, they can retry you, I suppose, because it's a mistrial, but generally, at most, they might try a person twice. If he gets acquitted twice, or if they have a hung jury twice, that's it. The other difference, which is universal in the United States, and used to be so in the United Kingdom, before under pressure from the European Court of Human Rights, at least that was one, I think, but our friend can correct me, motivating factor, is the rigorous application of the nebis in idem principle. Maybe as a result of A against the United Kingdom or otherwise, it is possible now, in some circumstances in the United Kingdom, for a person who has previously been acquitted in a jury trial to be retried. That is not possible in the United States, and I don't think the United States would ever enter in an arrangement where it would be possible to retry someone. Admittedly, in a world with many jurisdictions, and that's even possible in the United States, acquittal in a state court proceeding does not necessarily mean acquittal if one is prosecuted for a differently worded crime at the federal level. But that is rarely done, And the more typical way, which is how the O.J. Simpson situation was handled, was for people to bring a civil suit under federal law, and of course, they won an enormous amount of damages. But if you're interested in lawyery things, and I am, Florida is not unique. There are a couple of other states like Florida which allow you a homestead exemption from in bankruptcy on your home, and it doesn't matter how expensive the home is. So if you think you're going to be sued for some kind of malfeasance, the idea is to buy the most expensive house you can get, if maybe $20 or $30 million, and it makes sure it's your residence, as Mr. Simpson has insured, and they can't get it. It's just too bad. You know, you may say that's kind of funny, and I agree with you, it is kind of funny, and probably unjust. Let me express that view. But it shows you a mindset, if you will, as to the relationship of the law and the courts. So you ask, is the law an enemy or a friend? Well, I can say the law can be used by your enemies to make very, very uncomfortable for you. Let's leave it at that. So it's sometimes friendly, sometimes an enemy, and one has to use his wits to decide how to live in that circumstance. All right, now, I've already told you what the ideal would be. Let's assume, however, that you're not going to reach that ideal, as I assume we will not, for the foreseeable future. What can the courts do on their own? And there are some precedents, even in common law countries. And indeed, in a country like Germany or possibly Greece, the courts might be able to manufacture a law working with these broad generalizations. What can we learn from the common law on this subject? And I'd like to discuss that for a little bit. It might be helpful. At common law, one of the oldest forms of action is the action for nuisance. Nuisance, at least in modern terms, is distinguished between public nuisance and private nuisance. The older form is private nuisance, and I'll discuss that first. An action for private nuisance is when one person who has an interest in the use and enjoyment of land sues another person who is using his land in a way that interferes with the first person's right to use and enjoy his own property. The way the world operated in simpler times, or at least so it seems, is there was communal agreement as to what was considered to be an unreasonable use. So the courts weren't inventing the thing. For example, it was accepted if your privy overflowed and it got into someone's house, that was not good. And various other things. Or if you dammed up a stream and it flooded your neighbor's property, that wasn't considered good. But it was dependent on the notion of communal interest. And to some extent, that's been carried over into modern nuisance law. If your house is in an area where there are factories, what is a reasonable use of the land will be different from what it would be if you lived in a residential area. To wit, if you had your house in an area where there are largely factories, you'd have to put up with a certain amount of discomfort. That's just it. In a dynamic society such as the United States, neighborhoods change, however. And the old notion that you can't move to a nuisance, in other words, go somewhere where the uses are different from your use, and then demand that other people stop doing what they're doing, was probably never the law. But in fact, though, over time, regardless of whether it was or wasn't the law, neighborhoods change. And so you get situations, a number of cases in the United States where people are engaged in pig farming. A case that I remember when I first started teaching, I teach torts as well, involved pig farms in the outskirts of Boston. And it was an area which was given to pig farming, but gradually it was suburbanized. And it got to a point where the people who had the houses didn't want the pig farms, didn't want the flies, didn't want the smells. They didn't want to go back to nature or live in a what-have-you sort of situation. And they brought an action, and they won. Now, in the United States, I don't know what the law is in England on this, but in the United States, in most jurisdictions, once you could prove that there was a private nuisance, and you were not satisfied with damages, in other words, not satisfied with someone paying you for an easement in order to continue engaging in that property, you were entitled to an injunction to stop it.